Good afternoon, everyone. Thanks so much for joining us today. We are here for the May edition of our ongoing tenant landlord law series here at Homeline. Today, we'll be talking about recent city ordinances that have passed that are impacting tenants and landlords in Minnesota. So, since this is a city ordinance specific webinar. Not every ordinance is going to impact every tenant, and not every ordinance is going to impact every landlord, but this is a good way for trying to find out, what's going on across the state. So we'll get started here in just a minute or two as people get logged in to the meeting. We will be recording this session, so if you need to drop off or anything, you will be able to find it on our website later on, usually within a few days. And we'll also have a PDF version of the slides that you'll be able to access as well. All right, I'm just checking. Watching the ticker for people coming in. It looks like we've paused, so I think we're at where we're going to be at. So again, for those who were just joining us, thank you so much for joining today for our May edition of our ongoing series on Minnesota's tenant landlord laws. Today we're going to be joined by Samuel Spade, who is a housing attorney here at Homeline. He's going to be talking about some of the recent city ordinances that have passed, may or may not already be in effect. We'll get into that. But there's quite a few things going on at the city level as well, and those things do impact tenants and landlords. So it's important to kind of look at those every now and then, as well as the state and federal laws that we usually are usually referencing. So a couple of housekeeping things just to keep ourselves on track here. Homeline, if you're new, we are a nonprofit organization that helps tenants kind of navigate their rights under Minnesota tenant landlord law. We've been around since 1992, and at this point, we've helped over 335,000 renter households across the state. We offer free uh, limited legal advice to tenants in four languages, English, Somali, Hmong, and Spanish. And we also have an email attorney option. All of that contact information is right here. So if you are a tenant or know tenants who have specific legal questions about their situations, they can feel free to contact us. All right. A couple of housekeeping things just to let you all know. Like I said, the session is being recorded. It's going to be available on our website in a few days, along with a PDF version of the slides. Uh, we encourage and like your questions, so please ask questions that you have, either relevant to today's topics if they come up, or if we've got time and you've got kind of a more general tenant landlord question. Both Samuel and I are at this point experts in the subject in general, so we can try and tackle some questions as well. But again, use the Q&A function. If you put a question in the chat, there is a high likelihood that I am not going to see it because I'm going to be busy posting links to other things in there. And so please, please, please use the Q&A function that is at the bottom of your Zoom screen. If you don't see the Q&A option when you're in that little bar down at the bottom, then you may need to go to the circle with the three dots that says more, and select it from that menu. But again, please use the Q&A function to ask any questions, but we encourage you to do so. Love your questions, so bring them on. We will be applying for 1.5 CLE credits for this after this session is done. We will alert you with that code as soon as we have it. So if you don't know what a CLE credit is, then you probably don't need it. It's for attorneys who need ongoing continuing education credits. So all right, I think that is it for my housekeeping bits and bobs. So we're going to move on to city ordinances. Samuel, please take it away.
Hello. As Rachel said, my name is Samuel Spade. I'm one of the staff attorneys here at Homeline. I've been at Homeline for over 15 years now, and I am also Homeline's, research director and impact litigation director. I do have control over the slides, Rachel, or do you have control over them?
I'm in control.
All right, next slide. So first, the disclaimer, as Rachel said, we'll be talking about various cities' ordinances, but there are a lot of cities in Minnesota. So we're really only covering the recent ordinances or semi-recent ordinances in St. Louis Park, Minneapolis, and St. Paul. If you are aware of other cities that have new landlord tenant ordinances, please let us know. We do try to track it, but like I said, there are a lot of cities in Minnesota and we do not always see them or hear about them. So if you know of other cities that are passing ordinances, feel free to let us know and perhaps we'll do a webinar on them someday. But with that, next slide. So a lot of the city ordinances that we're going to be talking about are going to deal with pre-eviction notices. A notice a landlord has to give to a tenant, a residential tenant, before filing an eviction for non-payment of rent. Because of that, I wanted to take one step and just go over the statewide pre-eviction notices because that's going to apply regardless of what the city says. So under state law, at least 14 days before filing an eviction for non-payment of rent, and it is only an eviction for non-payment of rent. This doesn't apply to evictions for breach of lease or holdover or violation of 504B.171. But at least 14 days before filing an eviction for non-payment of rent, the landlord has to give the residential tenant a written notice. That written notice has to include a number of different things, such as the total amount due, a specific accounting of what's owed, who to pay it to. It also has to include 3 statements, essentially verbatim, and it has to be delivered personally or by first-class mail to the residential tenant. If a tenant doesn't fix the rent delinquency, if they actually owe the money, of course, if they disagree, they can argue or defend. But if they agree that they owe the money and they don't pay it within the 14 days, the landlord can then file an eviction for non-payment of rent. The Minnesota statute is 504B.321, subdivision 1A. And it specifically says that cities can require longer time periods. And we're going to be talking about 3 of those cities today. Also, just as a note, there is a 30-day notice requirement under the Federal CARES Act for certain types of subsidized housing and when the property itself has certain types of federal loans. So there might be a 30-day notice under federal law depending upon what your rental is like. But with that, let's go to the next slide and talk about St. Louis Park. I didn't have enough space in the titles to spell out the city names, so SLP will be St. Louis Park. We've got one slide on them because they have one ordinance that we're going to be talking about. This actually went into effect November 1st, 2024, so it's not really that new. It's about a little over 6 months old at this point. St. Louis Park required pre-eviction notice for non-payment of rent. They required it, I believe, even several years before the state required it, but they only required 7 days. And so now, as of last year, they have upped it from 7 days to 30 days. So at least 30 days before bringing an eviction action alleging non-payment of rent or other unpaid financial obligation, the landlord has to provide a written notice to the tenant um, basically saying all the same things that the state does. They have to explain how much is owed, who to pay it to, and so on. But most importantly, they have to use St. Louis Park's form. So St. Louis Park has a form. You can get it on their website. And landlords are required to use it. It contains all of the information that state law requires. So if you use the form, you comply with state law. But it also contains the information that's required by St. Louis Park. Again, this went into effect November 1st, 2024. And if you're interested in looking at the actual text of the city ordinance, it's section 8-355. And it looks like Rachel's already posting some links. So she's got the form there as well, it looks like. Next slide. As Rachel said, I'm going to move through these slides, but feel free to ask questions at any point on what we're talking about, and I will stop and answer those questions. But if I don't get questions, I'm just going to continue going through the slides. Next up, we have the Minneapolis pre-eviction notice. So we finished with the St. Louis Park City Ordinance. Now we're talking about Minneapolis. The Minneapolis pre-eviction notice. Also, they required 14 days notice before the state ordinance passed or state statute passed, but now they have up their notice requirement to 30 days as well. So they are up from 14 to 30 days. All the other requirements of the Minneapolis ordinance remains the same. So anyone who is working with landlords in Minneapolis or is a landlord in Minneapolis, I mean, you should have been following basically this rule for several years now. And it's the only thing that's different is it's gone from 14 days to 30 days. The city does have a form that you can use, but it is not required. If you use that form, you'll be complying with state law, though. So it is an option if you are in Minneapolis. But again, the Minneapolis ordinance doesn't mandate that you use the Minneapolis city form. The effective date for the Minneapolis pre-eviction notice is March 1st, 2025. Minneapolis City Ordinance number is 244.2060. If you are looking it up on their website, you actually have to click through the little amended link. It's not updated on Municode or wherever you're looking at the actual text of the language online. But again, outside of the fact that they crossed out 14 days and changed it to 30 days, this is the same ordinance that was in effect in Minneapolis for the last few years. Next slide. Now we get into some of the more interesting things from Minneapolis. So St. Paul does also have a pre-eviction notice, but I'm going to do this city by city, so we'll get to St. Paul's here in a bit. But Minneapolis also very recently passed some additional requirements. These also went into effect on March 1st. And make sure I get this right here. But the landlords have to disclose some additional information to a residential tenant prior to signing the lease and also within 90 days. So I'm going to deal with the disclosures that the landlord has to give pre-lease signing first. So before actually signing the lease with the tenant, the owner or landlord has to tell the tenant prior to the commencement of the tenancy, the contact information and the name of the person authorized to manage the premises, a physical address, so not a PO box. It's got to be a physical address of the landlord or agent authorized by the landlord to manage the services or manage the tenancy, accept service of process, receive and give notice to the tenants, etc. They also have to inform the tenant of the rental license tier status of the property and give the tenant any information regarding violations, housing code violations, etc., that contributed to the status of the property, and give the tenant a copy of all unabated orders and violation tags affecting the dwelling unit or common areas of the property. So basically, they need to tell the tenant, hey, this is how up to code the billing is, this is what the existing problems are, etc. If it is a multi-unit building, they also have to give the tenants an overview of how garbage, recycling, and organics work through the city of Minneapolis. And most importantly, and this is, I think, the big penalty, any tenant, if the landlord does not give these disclosures to the tenant, they have a right to terminate the lease after notice to the property owner. So they don't just get to walk out of the lease, but they have a right to terminate the lease by notice to the property owner. That notice must be as long as the interval between the time rent is due or 3 months, whichever is less. This basically mirrors the tenancy at will language under Minnesota state law, Minnesota statute 504B.135, which is the default notice requirement for a tenancy at will. And what that statute requires, and I guess what this ordinance requires to talk about this ordinance, is notice that is equal to the time between intervals between the time rent is due. So that's almost always going to be a month. If the tenant is paying monthly rent, that means 1 month. But if the tenant is paying less or more frequently than a month, so they're paying weekly or every other week, or less frequently than a month, which is rare, but they're paying less frequently than a month, every other month or every 2 months, every 3 months or something like that, is that interval of time, or 3 months, whichever is less. So in the case where, the tenant only pays rent once a year, which is very rare, but you do occasionally see it, or more likely the tenant is doing some type of work. So they're not actually paying rent, they're a caretaker, or their rent is performing some type of service or something like that. In those cases, it's 3 months. But basically, what it gives is the tenant a unilateral right to terminate their lease, effectively turning the tenant's lease into a tenancy at will for the tenant, not for the landlord, but for the tenant. So if the landlord doesn't meet these requirements, it gives the tenant a fairly easy out. Again, doesn't let the tenant just walk. It doesn't let them just, throw their hands up and leave. But it does give the tenant a fairly easy way to terminate the lease. Now, this is only going to apply to leases signed after March 1st this year because the landlord didn't have these disclosure requirements before March 1st of this year. But it is a way out for tenants if they want out. And frankly, one of the most common reasons tenants want out of their lease is repairs. We take a lot of break lease early termination calls here at Homeline. The number one reason tenants want to break their lease is repairs. So this might be one way for tenants to do it. Next slide. So those are the requirements that the landlord has to give to the tenant prior to signing the lease, but there are also some things the landlord has to disclose to the tenant after the signing the lease within the first 90 days. And frankly, the landlord can also give these notices all at the same time, which I think is actually how the city intends it. But the landlord has to tell the tenant about rights protected by federal law, state law, and city ordinances, give them the contact information for the Department of Regulatory Services, and such other information that the Director of Regulatory Service deems necessary. If that sounds a bit general, it's because, and I'm going to put this link here into the chat. Minneapolis actually just has a renters' rights mandatory disclosure form that they expect landlords to use. This covers all of the things that are required for both the pre-lease disclosures and the 90-day disclosures. You see that it has the name, physical address, phone number, links to the city's dashboard, recycling guidelines, and then links to rights protected by the city of Minneapolis, rights protected by the state of Minnesota, and rights protected by the federal government. Federal government is fair housing. State of Minnesota is the Attorney General's handbook. And the rights protected by the city of Minneapolis takes the tenant to, or whoever clicks on the link to the city of Minneapolis's website, which actually has a decent amount of information that is useful for tenants, including some that I didn't even know about, where the tenant has the ability to look up issues with lead paint for their property, get someone out to do a check for asthma, it looks like. If you click on the link for Healthy Homes, a request a free home inspection for asthma triggers, and a couple other things, regarding bed bugs, radon, et cetera. So there is some actual helpful information here for tenants that's easily accessible. There's also just some general helpful information that if you're an attorney, you might want to look at as well, some longer form, like hour-long presentations on some of the rights, some of the city ordinances that Minneapolis has had for several years. So these are the disclosures that a landlord is required to give to a tenant. Next slide, please. The effective date for both of these is March 1st, 2025. The Minneapolis City Code is 244-2000, sections 8 through 9. So these were already they're additions to the Minneapolis City Ordinance, a portion of the code that's already there. And there is, like I said, the specific penalty for landlords who fail to give the notice requirements prior to signing the lease. The tenant effectively gets a tenancy at will that they can terminate. But there's also just the general code city enforcement under 2150, which would allow the city to penalize the landlord, fine the landlord. I mean, they threaten criminal prosecution. I think I can think of like one or two examples of this ever. So that's not super likely, but it is in theory possible. And I think probably the biggest threat against the landlord in Minneapolis is the ability to yank the rental license, because once the city yanks the rental license, tenants effectively don't need to pay rent. They can probably leave without notice at that point, because again, there's not really much the landlord can do. So the city has the ability to enforce this as well. Let me stop for a moment. Do we have any questions on the Minneapolis ordinances or the St. Louis Park ordinance so far?
Nothing's coming up in the Q&A, but again, if folks have questions, feel free to drop them there and we can, you know, put them out there. Um, I want to also, I guess, make it clear, I'm dropping links into ordinance and things like that, but as Samuel said, the websites haven't necessarily caught up. They haven't been refreshed with the updated language yet. So some of the things that we're posting are the actual like amendment documents that um, the websites link to. You might have to dig a little bit more for the actual language. Okay, I think I have tried to fill time enough,
Yeah.
and I
Okay.
still don't see any questions coming in. So I think you have done a very thorough and excellent job thus far, I think is what that tells me. And you please continue on.
All right, so let's go on to the next section of Minneapolis ordinances, which is their change to the protected classes. So there are a number of things here. They have added several protected classes. They have revised a couple protected classes. They added an exception. All of these things will be effective August 1st, 2025, so they are not effective yet. Minneapolis City Code, they're in Minneapolis City Code 139.10 through 141.60. And there's a lot there because it's not just housing. This is discrimination. They made a bunch of updates to protected classes and discrimination, just generally, employment, et cetera. I'm not going to be talking about employment or anything like that. Me dealing only with rental housing and protected classes as it relates to rentals. But essentially, Minneapolis has added several protected classes and made it illegal and illegal discriminatory practice to discriminate against a person for the following things. Next slide. So the first class they added is height and weight. Um, I'm just going to look at the definition here so I get this right. So height and weight is defined as a numerical measurement of the body height, body weight, or body size, and it encompasses but is not limited to the impression of a person as tall or short, regardless of whether or not they're actually tall or short, and the impression of their weights, regardless of their actual weights. And it includes scores, ratios, or metrics that involve measurements of the whole body or part of the body. So it's pretty broad. I mean, this is, I mean, hopefully something that I think is self-obvious, but landlords should not be discriminating against people based upon their body size, whether they are too large, too small, too tall, too short. According to the landlord, that shouldn't be taken into account. So that's the first new protected class. Next one. Again, I'm going to find this so I get this right, because these are very new here, but housing status is the state of having or not having a fixed, regular, and adequate nighttime residence. Essentially, whether or not a person has a home, whether or not they are homeless, staying in a shelter, where they are living, etc. So again, landlords are no longer allowed to discriminate against the person because of their housing status. This is going to be an interesting one for landlords because landlords are obviously still going to want to check past rental history. They're going to check rental history, et cetera, but they should not be using the tenants or the prospective tenants' housing status as a reason to rent or to not rent to them. Next slide. So the next change is a change to familial status, which again, I'm going to try to do these as close as possible. So uh, this is very similar. So the familial status is already a protected class, but now it includes not just having a minor in the home, but individuals who lack the ability to meet essential requirements for physical health, safety, or self-care because they are unable to receive and evaluate information or make or communicate decisions. So somebody with some type of mental handicap or disability that makes it harder for them to do certain things also now counts for familial status under Minneapolis city ordinance. So again, not something the landlord should be using to discriminate. This I think is probably also covered under several other things in both state and federal. You've got protected classes for disability, et cetera. So hopefully this does not come as a shock to anyone. Landlords should not be using this to discriminate against anyone. Um, I do see a question here. If housing status can no longer be used to discriminate, can a landlord no longer require that a renter has any prior rental references? Honestly, this is a very new ordinance. And I'm not aware of anything like this. It's certainly not a federal or state law. And so I think that the answer is a landlord can probably still ask for rental references. And I mean, most landlords are getting this information through some type of rental screening process, et cetera. But the landlord can't be denying people because of their housing status. So, for example, I think it does make it hard to deny a person because they don't have a rental reference. So if they say, I'm homeless, or wherever they're living, and I don't have a current landlord, the landlord can't say, all right, well, we're not going to rent to you then. Um, but if they ask and the tenant gives a rental reference, from a year ago or something like that, I don't see why a landlord couldn't check with that rental reference and see what the reference was. Or, if they run a tenant screening report and the tenant screening report has negative rental history, use that. Again, assuming the landlord is following the other requirements of tenant screening, which is under Minnesota state law and so on. Doesn't the ordinance protect individuals if they have no previous rental history? Yes, I mean, I think this is what I'm saying. The landlord can't use the lack of the rental history, especially depending upon why they have the lack of the rental history, as a reason to not rent. But I do think the landlord can still ask for it. And if they find out information, or again, the tenant screening company has information, that's reported, they can use that information. Again, they can use negative information where the land, like a previous landlord says this tenant owes rent. That's the type of information I'm talking about that they can use. But I do also want to say, again, this just went into effect and it is not even active yet. I'm not aware of any other places. There probably are some in the United States, but I'm not aware of any other places enough to answer this directly. So I think a lot of people are going to be asking similar questions, trying to figure out exactly what this means, what's allowed and what's not allowed. But I mean, I think one way to do it is to really ask, why are you saying no? If you're saying no to someone and it's related to the fact that they don't have housing, that's the obvious red flag. That's what a landlord should not be doing. All right, so I'm about to move on to St. Paul. If we have no other questions, um, let me stop for one more minute here, see if we have any other questions related to Minneapolis or St. Louis Park.
And Samuel, forgive me. I know that the new protected classes just passed. So they're effective August 1st of this year, though, right?
I think so. I have to go back and look at my own slide here to know for sure. But yes, whatever I put on the slide should be right there.
I mean, yeah, I I trust
Yeah.
that. Um, so it's just this was one of the ones where had been trying to find the link to the amendment and it was struggling to find that information. So
Okay. I have the link, which I will put in here. I
thank you.
think this will work. Um,
Worked
Again,
for
yeah.
me.
All right. Yeah. So this is one where it's a modification or amendment to Minneapolis's existing um, Title VII relating to civil rights. Uh, So if you are an attorney and familiar with reading how ordinances work, should be clear, but it will not be, you've got strike throughs, you've got underlines, you've got all of the changes that have been made as they're going and updating their current ordinance.
Mhm. All right. Don't see any other questions coming through, so I'll let you get back on with it.
All right, so let's move on to St. Paul. All right, so St. Paul has sort of two sections of things. First, as you can see by the title of this slide, they rolled back um, their St. Paul rent cap for a lot of properties. And then they also passed a lot of additional protections for tenants. The St. Paul rent cap rollback is pretty straightforward. It's very short. They just modified their existing ordinance. So that's chapter 193A, point oh 0.08. They have some exceptions already that already existed. And they simply added more exceptions, primarily for properties built after December 31st, 2004. So it's not a typo. It's not 2024, it's 2004. So 20 years going backwards, or that became residential properties. so that they first issued their first building certificate of occupancy, which is effectively St. Paul's rental license, after December 31st, 2004, are exempted from the limitations on rent increases. This is a pretty big exception. I don't know what percentage of St. Paul housing, this will affect. But the last 20 years, new properties or properties that became or want to become, so if a place is not currently a rental property and someone wants it to become a rental property, they'll fit within these exceptions. Uh, Again, this is again, a fairly minor change as far as what the text was changed of the existing ordinance. They just added this exception. And that's pretty much all there is. Again, St. Paul just changed it. And I think that their idea here is that it will make it easier for new developments and new people to get in while still adding protection, uh, keeping a lot of the places protected. Again, at least some of the things I read said that this will affect the minority, not the majority of St. Paul rental housing. Again, I don't know if that's true or not, but certainly a fairly broad exception, but it is not everything. Obviously, St. Paul will have a lot of older property. It's been around for a while, so it won't affect everything. And then next, St. Paul passed a bunch of tenant protections. And I'm going to go through these, but the important thing to know here is that it's not effective until 1 year from the date of signing. So the date of signing, I believe, was May 7th. I might be a day or two off there. But basically, it won't be effective until a year from now. And so I'm going to cover them, but they are not going into effect for quite a while. This is part of St. Paul City Code Chapter 193. This section or chapter was sort of already the law for a bit, and then it was taken away. The city repealed it. Back in, I think I'm going to get this wrong. I didn't look this one up and write it down. I think it was 2021 or 2022. They repealed the safe housing, which had the good cause protection and a bunch of other things. They did not add in good cause protection, but they did add in or redo a bunch of the protections that they had at that point. Um, I think that part of the reason for the year-long delay is that the city has some work that they need to do first to make some of these things that they're requiring capable. So, for example, the city is supposed to maintain a website now that has information, resources, and rules and enforcement tools necessary for the full implementation of the chapter. And they've got to publish some materials and translate those materials into different languages, publish notices for the landlords to provide to tenants, because the landlord is going to be required to provide some notices to tenants under this chapter, et cetera. So I think that that's the reason that or at least part of the reason that they put they put this a year out, because they've got some work to do to make this work. But with that, let's start going through it. So St. Paul added their own pre-eviction notice. St. Paul currently does not have any pre-eviction notice. So Minneapolis and St. Louis Park had prior ordinances. So St. Louis Park required 7 days, and Minneapolis required 14 days. St. Paul didn't require anything, but they have added in at least 30 days notice prior to filing an eviction for non-payment of rent. Just like all the other ones, this is only for non-payment of rent. It won't apply to breaches of lease. It won't apply to holding over. It's just non-payment. And it requires all the information that the city ordinance, or sorry, that the state ordinance requires. The city ordinance requires the information that the state ordinance requires. So really, it's just 30-day notice. It's provide the information you're required to provide as a landlord under state statute, but do it 30 days in advance rather than 14 days in advance. That's section 193.04. Next slide. They also put limitations on security deposits and prepaid rent. So this one is very similar to Minneapolis's ordinance. Minneapolis also has this requirement, and it's been around for many years, but it also has its requirement. I do see that question. I'll come back to that in just a moment. Um, it puts a limit on security deposits amount. No landlord may charge anything more than a single month's rent as a security deposit. It also puts a limit on prepaid rent. And I think by this they are referring specifically to prepaid rent for like last month's rent, but it is written pretty broadly. But it says no landlord may demand, charge, or accept prepaid rent that exceeds the equivalent of a single month's rent. Um, but this is separate from a security deposit, pet deposit application fees, et cetera. And the only real exception to this is for applicants whose rental application could be denied under their new applicant screening guidelines, which I'll cover in just a moment. So basically, landlords are capped at full month's rent for security deposit and a full month's rent for prepaid rent. Um, but if the tenant wouldn't really meet the applicant screening guidelines, the landlord's going to make an exception and let them in, then they can charge a double deposit. So they can charge a double deposit, effectively a sort of extra protection to the landlord. And of course, landlords still have to comply with Minnesota Statute 504B.178, the state law that governs security deposits. So there's nothing there. It's just a pure cap on how much a landlord can charge for a deposit and how much they can charge for prepaid rent. To answer the question, when did St. Paul change to 30 days? They have not yet changed. This is all part of the ordinance that goes into effect a year from now. So they passed the legislation like 2 weeks ago. They passed it after we had decided to do this CLE, this presentation. Uh, like in, it's not in effect yet, but um, will be in effect next year unless something changes before then. So there is no 30-day notice requirement right now, but there will be next year. And again, the state statute, the law is all out there. Um, and did we link to this? Yeah, it looks like we did. Uh,
I linked to the best that I had, which
I
is, yeah, if it, I guess that's a good question as well. Maybe you can go over that in a minute if it's not appropriate here. But like, obviously, a lot of this stuff, as I was saying, isn't available on their websites yet, but there is stuff here. How do you find it?
That is a good question. Frankly, part of why I have all of these codes is so I can find it later because it is a little bit difficult to find. Every place is a bit different. St. Louis Parks, just going through what we've done so far, St. Louis Parks, that's been around long enough that it is just part of their city ordinance. You can just look it up. Minneapolis, if you go to the Municode website, a number of them have a little note under the appropriate section that say appealed, where you can just click, or not appeal, amended, and you can click on the link and you will get the amended link. You will get the link to the amended documents. But the I'm blanking on the word here. The changes to the discrimination laws actually uh, I went to LIMS, with lims.minneapolismn.gov, which has all of their legislation and history and that type of stuff. And it's a bit more complicated um, to figure out how to find things there. Frankly, I had links sent to me for a couple of these as well by people at Homeline who know a little bit more about navigating the city ordinance side of things. So that's where I found it. And then St. Paul has their own thing that is very similar, which is St. Paul or stpaul.legistar.com, which has all of their legislation details. It's very similar. It's just all of the stuff that they do for the city ordinances posted publicly. And again, because it's not part of their ordinance, you do get the strike through and underline that you get when you're reading um, existing ordinances that are being changed, where strike throughs are stuff that are being removed, underlined is stuff that is being added, and text that is not struck through or underlined is the existing text. I know all of the attorneys on this call probably know it. For those who are not attorneys and were linking this stuff, it was definitely confusing for me when I first started seeing documents like this. And so that's how to read it. But yeah, if you see these links where it's underlines means addition, strike through is stuff that was existing in the ordinance and is being taken out.
All right.
Um,
That's
All
really
right.
helpful. Thank you.
You're welcome. So another question. So if they were going to reject someone's application, they can offer them an opportunity to pay double deposit instead of getting rejected. Effectively, yes. Although let's talk a little bit more about that with our next slide. So there's now, again, I say now, it is passed, but it's not effective yet. It doesn't become effective until next year. But there are now applicant screening guidelines for prospective tenants that the landlord has to use, as well as some rules about application screenings and fees. So the first is there's a rule now. Again, I'm going to keep saying now because it is there, but just remember it's not in effect yet. But there's a rule that says application fees cannot exceed the cost of the screening process. So the landlord can't be charging the tenant $100 and then paying the tenant screening company, $40 or something like that. And written information on the actual cost of the screening process must be made available to the prospective tenant if they request, or actual tenant, if they request it after they become a tenant. There's also a bunch of rules now about what the landlord is allowed to screen for. This is also very similar to how Minneapolis has their screening criteria. So first, the city sets out a uniform screening criteria, which says that the landlord, then they say that the landlord has to use it unless the landlord wants to follow an individualized assessment. So the uniform civil screening criteria, I'm not going to just read it here, but I think that here, I'll put the link in again. I think I already did it once, but if you go down to section 193.03, for those who are on their computers and very industrious, you can see all of this, and I'm going to paraphrase here. But basically, there are now limitations, or again, will be limitations on criminal and civil case history. Landlords can't deny people for arrests or charges in inactive cases that didn't result in conviction of a crime. Any court file that is not public or has been destroyed, conviction for crime that is no longer illegal in the state of Minnesota, adjudication in the juvenile justice system with some exceptions, petty misdemeanors that aren't criminal offenses, and a couple other things. I'm not going to read them all, but there's more rules around certain types of crimes, the ones you might expect, like certain types of felony offenses, especially criminal sexual offenses. There are uh, different restrictions, and landlords have more freedom to deny tenants for those. There's also a restriction on credit history. Landlords are not allowed to just deny someone based upon the credit score itself. They can use the credit report information to the extent that it demonstrates a failure to pay rent or utilities, but they can't just say low credit, you can't rent here, or insufficient credit, unless, again, the applicant in bad faith withholds the credit information. So there's limitations on criminal and civil, credit history, rental history, can't be denied for a pending eviction action. This is already the rule now under state law. Can't be denied for eviction action that has not resulted in a writ of recovery, or a couple other things. Again, a lot of these things actually are now state law, which I know this is not really part of our presentation, but this was a fairly new addition. But under Minnesota State Statute 504B.173, landlords cannot deny rental applications based on any of the following: a pending eviction action, any court file that is not public or has been expunged, any eviction action that has not resulted in a writ of recovery. So those three things are required under state law. So to some extent, again, I'm saying that the St. Paul ordinances are not in place yet, but the state statute is effective. So this is actually already a law, already required. Landlords are not allowed to deny tenants on a pending case that has been expunged or destroyed or made confidential, or where the writ didn't issue. And then, so back to St. Paul, if the landlord doesn't want to use the uniform screening criteria, they can use an individualized assessment, which has different requirements, but essentially the landlord must conduct an individualized assessment, go through things, let the tenant supply supplemental information, other things that might mitigate or uh, show that they're still going to be a good tenant, et cetera. And then the landlord has to follow even more rules if they want to deny after the individualized assessment. So all the way back to the question that I got at the start of this slide, if they're going to reject someone's application, uh, then yes, under the individualized assessment, if they want to say, all right, we will accept you because even though you don't meet the uniform screening criteria or individualized assessment, we're going to accept you, then you could charge a double deposit. And again, that part not in effect yet, won't be in effect until next year. Any questions on applications and screening? Okay, let's go to the next slide. So next up, relocation assistance. There's a couple different things here, but basically, uh, if there is a sale of affordable housing, and this does only apply to affordable housing buildings. So there's a definition of what affordable housing is. I don't actually have that memorized. I can go look it up if anyone is curious. But if there's a sale of an affordable housing building, the new landlord cannot terminate or non-renew a tenant's lease, um, raise the rent, or rescreen existing tenants during the tenant protection period, which that I should know. I believe it's 90 days, but I want to get that one right. 3 calendar months. So for 3 calendar months, the new landlord cannot terminate non-renewal lease, raise rent, or rescreen existing tenants, um, except for costs. Also, as soon as practical, but no later than 30 days, they have to tell the new landlord, or the new landlord has to tell the tenants with a written notice, the name and mailing address and telephone number of the new landlord, a specific text, which I'm not going to read because it's a paragraph long, but basically talking about the tenant protection period. They have to give that to the tenants verbatim. And then there's a couple other requirements as well, and that they have to cover. Um, and if the landlord, any new landlord must then also pay relocation assistance if they do any of the following things in the tenant protection period, the 3 month time period. So if they terminate the lease without cause or non-renew, raise the rent, or do anything like that, they owe the tenants relocation assistance. And this is under St. Paul City Code 193.05 through '06. Again, this is not for all properties. This is only for affordable housing. And affordable housing, I should get this definition right as well, means a residential building where at least 20% of the units are affordable housing units, and an affordable housing unit is one where rents for no more than 1/3 or 60% or below the area median income. Um, so it's not like you apply to be an affordable housing unit or something like that. You're just looking at the property, looking at what the rents are on that property and whether or not they're affordable as defined by the city ordinance. And if there is, and there's a sale, then all of these things get kicked in. But again, not effective until next year. Next slide, which I think might be the last slide here.
Yep, it is. I was busy trying desperately to find the definition of affordable housing while you were talking, and I gotta say that Legistar site is not user friendly.
No, it is not. It is
So
not meant to be. I don't want to say it's not meant to be user friendly, but I think they made it for the people who know what they want out of it, and so it has all the stuff that they want for themselves, etc. But if you don't know what that is, it is a pain to use. But there's a link, and I mean I'm finding it by basically hitting Control F in my
yeah,
browser and then just searching the phrase that I'm looking for.
that is exactly what I did too. Because yeah, it's hard to find the actual language in here. I feel like I'm kind of just going in through circles of pages and links, but it does exist, obviously. So thank you for digging through all of that as we're just discussing. Like, obviously, that's not finding these ordinances are not the easiest thing to do, especially because city councils have their sessions kind of as they will, and so it's not always clear like when these things are coming up for discussion. Again, we try to keep an ear to the ground on these sorts of things, but I think I used to work for the League of Minnesota Cities, and I think we said there was like 183 or maybe I don't remember a whole lot, hundreds of cities here in Minnesota. Um, and so not all of them have rental licenses, none of them deal with rentals, but at the same time, a lot of them do, and how they go about that is kind of their own path. So I think what I'm trying to say is, if you are a tenant or a landlord or a service provider, anyone who's trying to get more information, make sure to also check where your rental is located because there's more stuff in there.
Yeah. And so while we wait for just a bit here to see if there are any questions, let me just do sort of a quick summary because we've talked about a lot. So for St. Louis Park, only new ordinance that we talked about is the pre-eviction notice. That's 30 days. It is in effect. It has been in effect since November 2024. For Minneapolis, there's a number of different things. There's the 30-day notice, pre-eviction notice. That is in effect March 1st already, so it's also in effect. Um, and they also have their pre-lease disclosure requirements and their post-lease or within 90 days disclosure requirements that are in effect as well. So these are the three ordinances that are already in effect. And it should go without saying, if a landlord doesn't give the proper notice, 30-day notice, the case gets just dismissed. So if they're not giving the notice under state law, or in the cities that have these longer notice requirements, not giving a notice under the longer notice requirements, the case gets dismissed, the tenant wins. And for the pre-lease disclosures, tenants essentially get an easy way out of their lease. Um, and for the protected classes, those are not in effect, but they will be in effect August 1st this year. So they will be in effect soon. And then for St. Paul, the St. Paul rent cap rollback, I believe is already in effect. Actually, that's the one thing I didn't write down the effective date, but my understanding is it is in effect. And then the St. Paul tenant protections, there are a lot there, but they will not be in effect for another year. And yes, what does the pre-eviction notice look like for Greater Minnesota? Is it 14 days? Yes, for Greater Minnesota, or really for all of Minnesota, if it is not in some city that has a longer requirement, it is the state statute, 14 days. There is not a required form. However, the state does have one, which I'll link to. This again, this form would meet the requirements of state statute, but the state does not mandate that the landlords use this form. So they could write their own form so long as they follow the requirements of state law. But it is 14 days for everywhere that doesn't require more. And there's no city that could require less or like Trump state law. They can only give more.
Okay. Here's the rent stabilization information. It's here. Um, yeah. So, all right. So that was Issa's question. Thank you so much, Issa, for your questions. I don't have any more coming in from our audience here. Um, the so Minneapolis has had some of these, protections in place. St. Paul had similar protections we just talked about. They were implemented in 2020, but then almost immediately repealed in 2021. Um, and so this is what appears to be a slightly reduced and slower rollout than what they had before. Is that
Yes, I think that's
accurate?
fair.
Yeah.
Yep.
So, um, but I th these sh as you said, like a lot of these things are already a part of state law. I tried to link to all of the statutes that I could that we were discussing. But we do have a really good overview of the new laws that went into effect on our website as well, for both went into effect on 2024 and 2025. Um,
The state statute
yes.
overview. So I was like, not the city ordinances. We don't have that up yet. We are going to try to do that.
Hmm.
So we will be trying to do that. I do also want to say I should give credit. It does not cover everything we talked about, but there is a fairly good summary as well as links to some of the laws from John Roach, who's an attorney who works with both landlords and tenants. He has a fairly useful summary of the pre-lease mandatory disclosures and the 30-day notice for Minneapolis, as well as links to at least one of the ordinances as well.
Hmm.
Um, so that was very, very helpful in finding a couple of these things for me originally, and might be helpful for other people too.
Yeah, one other one that I saw in Minneapolis that passed the city council, but I'm not 100% certain when the effective date is the landlords not being allowed to use AI to generate their rental rates.
Interesting. I did not see that one in my research. I think I know what that's referring to though, but that would be
Mm,
a topic for a much, much longer
yeah.
CLE.
Hmm. Yeah, it was in response to some other, larger concerns about AI generated rental rates not necessarily being uh, the best for both tenants and landlords. Um, but I I even listened to that city council debate, like I had that video on, and I still wasn't certain what the effective date was. I know it passed, but I don't know like when it's into effect. So that's something also though to keep in mind is that it's that is there. I know not a lot of landlords necessarily use that, at this point. I think this is a ordinance that's trying to get ahead of a problem. But um, yeah, like, as Samuel said, this is something that I knew about that he doesn't necessarily, find in his research. And he's our research guy. He's our research manager. So he's really good at his job. Um, so um, if anyone has any other ordinances that they are aware of, either in the metro or, in greater Minnesota that would be relevant, feel free to, drop that information into either the chat or into the Q&A, and we're happy to share those out as part of this recording and presentation. But otherwise, Samuel, I don't have any other questions for you. If there's anything else, we're going to end a little bit early today, which is great. It's a nice afternoon to go curl up with some internet and maybe do a deeper dive into city ordinances. So maybe that's everyone's homework who's watching today is we just posted a whole bunch of links to all these fun ordinance sites. Go take the next half hour to go familiarize yourself with those because it may take that long just to find language to a single ordinance. So with that, thank you all so much for coming today, and I hope you have a good rest of your day. I do want to say, on a more personal note, this will be my last hosting for our Homeline presentations. I will be transferring that torch off to other folks here at Homeline. So still going to be the same great, content and things. It just won't have my face attached to it anymore. So uh, take that as you will. Thank you all so much for all of the wonderful times I've had, and I hope you all have a great rest of your day. And we'll be in touch. Thanks all. Bye.